of all of the works and categories of works, for example, logos, technical drawings, product specs, manuals, photos, corporate ID documents, databases, computer programs that you own or that you use. And then let us know what know-how, such as processes, methodologies, technology formulae that are used or owned by the company. Now that sounds like a really tough set of questions to answer, but what are we actually looking for? Well, firstly, we want to know what IP does your company actually have? Do you have any patents? Do you have any trademarks, domain names? Do you have any registered designs? What copyright works have you created? What IP is there? And then secondly, have you taken steps to appropriately protect that? And if you have, is everything in order with those registrations or that IP? Do you actually own the IP that's important to your company? You won't believe how often it happens that a company has developed an amazing piece of software, but they've used outside developers, and the contract with that outside developers doesn't say anything about IP ownership. And in that situation, all that you have is a license from the development house. You don't actually own your own source code. And that would obviously be a major red flag to any investor. Usually the kind of thing you can fix, but the kind of thing you want to fix before you invest in a company. And what is the status and validity of the IP? You know, have you been paying your renewal fees if it's a patent or a trademark? Are the rights granted, or are they simply pending? And so all of that information is to assess what IP does this company have. And I think the key takeaways for a startup company is really just keep this information together and accessible. You might want to consider establishing a data room, which could just be a Dropbox folder or maybe somewhere on your own systems where all of this information is just kept together, and you can just provide the information easily. And we're going to look at some of the other steps that you can do to actually manage the IP at the end. I am hearing a little bit of feedback. I suspect it might be one or two people who don't have the mute button on. So perhaps if you wouldn't mind just muting for me. You're welcome to post questions in the chat. And then I think let's get through perhaps some of the the substantive portions of this talk, and then we can address those questions at the end. Once we've had a look at what IP there is, then we look at what agreements are there. You know, what agreements have you actually made? What contracts have you signed with third parties? So the questions we ask are, please supply copies of all agreements in terms of which the company has the right to use any IP owned by third parties. So those would be inbound licenses. All agreements in terms of which the company grants third parties, related or unrelated, the right to use any of its own IP. So that would be outbound licenses. And all other agreements relating to IP, such as coexistence agreements, consents, and assignments. Coexistence and consent agreements are specific to trademark applications generally. Assignments is a transfer of rights. So that's where you've actually sold or transferred ownership of IP. And then very importantly, please advise whether there are any unwritten agreements or arrangements in the nature of the above, and if so, provide details. I'm sure it won't come as a surprise that many times we do things on a handshake instead of reducing it to writing. And that can, of course, become a red flag for an investor. If there's a verbal agreement, for example, to do something involving IP that hasn't been written or recorded in writing, we need to know about that during the due diligence phase. Then we need to see any confidentiality or non-disclosure agreements or any other agreements containing confidentiality or non-disclosure provisions. So what have you done to safeguard the confidential information that you own, and what obligations do you owe to other companies or parties as far as confidentiality goes? And then the third question here is a very important one. Does the company make the use of the services of any consultants or independent contractors? If so, please provide details of such arrangements, including the nature of the services performed and copies of all relevant agreements. This is almost inevitably applicable to startup companies. You can't do everything yourself, so you hire a development house, or you hire a website front-end developer, or you get someone to design your logo. All of these are third-party consulting agreements, and the general principle, at least in South African law, is unless that agreement contains a clause stating that the IP that's produced by the consultant is owned by you, they actually own the IP and you just have a license to use it. So these three questions here are all aimed at answering the following bullet points on the right. This is kind of what's in the mind of the attorney who's doing the IP due diligence. So what third-party IP are you using? And do you have permission to use it, right? We want to make sure that you're not simply using software that you don't have permission to use. And do any third parties use your IP? Are there informal arrangements that are not governed by written agreements? I touched on that when we spoke about the importance of just putting things in writing. Have you protected your confidential information, or are third parties allowed to take the information that they get from you and simply share that further? If third parties are doing work for you, do you own their work product? Or can they easily just take that know-how to a competitor? That would also be a red flag for an investor in an IP due diligence. So the key takeaways here are, just like that data room I spoke about under keeping track of your IP, record all company agreements and obligations in writing. Have these agreements actually set up. And by writing, it could even be an email that's acknowledged, is better than simply a verbal agreement. And then keep your agreements in that data room. The next thing we look at in an IP due diligence is, how is the IP actually generated by this company? So here we want to know about the R&D that's being done, both within the company and or using third parties, which could give rise to products likely to have a substantial impact on your operations. And we specifically want to see copies of the documents. Are you using third parties to do your research and development? And what research and development are you doing? Do you have systems for regularly reporting inventions that are made by research staff? This is probably something applicable to a larger company than a startup, but it's still something that, you may have a system. You say, well, here's a form you've got to fill in when you've got a good idea, and then we consider it for patent protection, for example. And then let us know about any patent agents or patent attorneys that help you monitor and advise on those inventions that you make during the course of your business. And what we're trying to look for here is really to understand, what research and development do you do? Is your company one that's generating new IP, or are you simply a services business that's servicing customers? Because if you are generating IP, is any of it likely to be patentable, for example? And if it is, do you have a mechanism or a process for identifying that and dealing with it? And if you're using third parties, if you're outsourcing any aspect of this process, what do those agreements say? And do you actually own the IP that's being generated in the course of your research and development? So again, the key takeaway over here is, if you do research and development, and I would imagine most of you who have businesses that create software and are solving for problems are doing development, you need a process for protecting the output. Now, that process could simply be, we make sure we own it, we keep our source code secure, but you might want to go one step further and say, let's engage the services of an IP attorney and see if anything we do is potentially patentable, or if there are other forms of protection we need to consider. Next, we turn to the issue of IP created by employees. I'm sure it won't surprise you also that most young companies begin with very simple or perhaps thin employment contracts, if any. Perhaps again it's just a handshake. At the time of doing an IP due diligence, we're going to want to know if employees are bound by a standard employment contract. And if they are, we're going to want to see a sample of that contract and a list of the employees that have signed it. And we're going to want to know if there are employees that are not bound by a standard employment contract. And so we're going to want to know what agreements apply to all employees. And do those agreements have appropriate assignment of IP and confidentiality clauses? You'll see that's the first bullet point at the top right. That's what we're really trying to figure out here. And then under point 2, please confirm that all persons retained or employed who in the course of their work will or might reasonably be expected to bring into existence IP are individually bound by agreements where such IP vests in or must be assigned by the company. If not, detail any omissions and provide us with copies of all documentation. So again, we want to make sure that the employees and all persons who are working on your IP development have actually agreed to assign IP to the company. It's a little bit of a patchwork when it comes to IP law. As far as copyright is concerned, if you work for an employer under a contract of employment, then the employer automatically owns the copyright. So for example, the source code. But for different forms of IP, like patents don't automatically belong to the employer. There's nothing in the Patents Act that actually automatically assigns ownership of patents to an employer. You actually then have to get your employees to sign an assignment of invention. And if they refuse, you've got to show that they're obliged to do so. So you really want to have in your employment contracts language that says that all IP created by this employee belongs to the company. And likewise, for confidentiality, an employee needs to know that they're not at liberty to disclose company confidential information. And when they leave the company, they need to return all confidential information. It's very important to have those provisions in your employment contracts. And then the final question we ask during an IP due diligence is, if applicable, furnish us with details of other agreements with employees regarding confidentiality, use of IP of the company, and ownership of IP created in the course of their employment or consultancy. Sometimes it happens that you hire someone initially with one standard contract, and then later on they sign a separate IP contract. We need to figure out all of those obligations to satisfy the investor that the employees are obliged to transfer ownership to the company and that they can't simply disclose company confidential information. So key takeaways here are really coming up with a standard employment contract, which has both IP and confidentiality clauses. And then I want to take a moment to talk about this issue of a restraint of trade. I'm sure you've seen this in some employment agreements. Interestingly, in some countries, restraints of trade are completely unlawful. So in California, for example, you may not put a restraint of trade on any employee. You can't stop someone from leaving and working for a competitor. But in South Africa, they are still enforceable, as well as in much of the rest of the world, provided that you have a protectable interest and the restraint is reasonable. So let's just talk about that a little bit. A restraint of trade is where you put a clause in an employment agreement that says, once you leave your employ, you may not work for a certain period for certain employers. And it's a kind of a blanket statement, even if you haven't taken confidential information with you. So you are restrained from trading effectively for a period. And you can understand why that can be problematic, because we all have a constitutional right to work, and it's a limitation on that right when you are now told that, if you leave this particular software developer, you can't work for any other software developer for a year, for example. So restraints of trade are only valid when the company has a protectable interest. So where this employee was really integral or exposed to such sensitive information that if they took that with them, or if they even took their knowledge of how the company works, it could really harm that company. That's the first requirement. There must be a protectable interest. And then the second requirement, the restraint must be reasonable, both as to duration and geographical area. So I would guess for most of your businesses, you should not put restraint of trade clauses in, but it's something you should think about. If you are in a very niche industry, if your employees, or certain employees, are exposed to very sensitive information, you may consider including restraint of trade clauses into your employment agreements. The next thing we really focus on in an IP due diligence is IT and software systems. So we want to know all software that's used by the company and a classification of whether it was developed internally or developed by a third party. So here we're asking who developed the software, was it company software that's being used, third party software, and which pieces of software are owned by who. And then we want to know a list of all developers involved in design and development of software, including the name of the software, developers' names, employer of the developer when they develop the software, who currently employs that developer, when they started development, agreements relating to the developer's conduct and rights into the software, and then finally, any open source software or open source coding used to design and develop the software. The reason we ask such specific questions about developers is twofold. We want to make sure, are the key developers in this business still employed by the business? It would be a red flag for an investor if the main developer who developed the software had just left to join a competitor, for example. That you'd want to know about that before you invest in this company. You'd also want to know if this developer was actually employed by someone different at the time of doing the development, and they then subsequently joined the company. But at the time of doing the development, they were under contract, and that contract didn't address ownership of IP. That could also be a potential red flag. So we want to know, are the developers still employed? And if they were brought in from outside, was any of the development done while they were outside? And then finally, we want to get details of third parties that have the right to access the company's systems. So we want to know here, what sort of software integrity and security processes are in place. So what can you do to prepare for these kind of questions when they come during an IP due diligence? Well, the first thing you could do is you can ensure your developers are employed and that you have employment contracts, or if they're under consultancy agreements, that those agreements include IP and confidentiality provisions. And if they don't, you can fix that. You can go back and say to your developers, guys, this is something we need to address. Let's just sign an addendum to the agreement clarifying that the company owns the IP. And usually that isn't an issue. You can ensure that the way you commercially exploit your software doesn't interfere with any open source license terms. So I'm sure many of you are using open source software as part of your business, and that's fine. But you want to take a look at those licenses and see what the restrictions may be, if any. And you want to make sure that the use of the software that the company is using isn't in breach of the open source license terms. So, for example, most open source licenses require that your software also be made open source if you are supplying that software. So, for example, you can't create a software system which you sell as for example, a desktop app or an app that makes use of open source software, because then you've closed sourced it. So you have to look quite carefully at those licenses to make sure you're not in breach of the OS requirements. And then you want to make sure that the company has appropriate data security processes and policies. That's a little bit beyond the scope of a IP audit or an IP due diligence. Data security is obviously a whole field of its own, but we do touch on it by just looking at which third parties actually have access to the company systems. So IT and software is obviously a huge part of any due diligence for a tech business, and it also is something that the IP attorneys will be looking at fairly closely. We'll also dive more deeply into your software licenses. So we're going to want to know that all software is either owned by or licensed to the company. And if it's licensed, we want to see copies of those license agreements. We're going to want to see the nature of each license. So is it a single user, a site-specific license? And how many actual users are there and how many permitted users are there? I think you can see what we're getting at here. If you're using a student version of some piece of software, and you're running your company on it, and you're in breach of the software license because you're using a trial version, for example, where you should be using a full commercial, that's something that your investors will want to know about prior to investing, and it's probably something you're going to want to fix prior to investing, because you don't want that liability potentially to fall on the company post-investment. If there have been any breach of license obligations in the past, going to have to know about those. Perhaps the company can get an indemnity from the founders for anything that had happened in the past. State whether any licensor has given or threatened to serve notice of any alleged breach of license terms by the company. So if you have been licensing your software, have your licensors ever threatened breach? Have you failed to pay, for example, or have you used the software in a way that wasn't authorized? Very unlikely that would be applicable, but we ask the question nevertheless. And then provide us with details of all licenses, including informal arrangements and free distribution and electronic distribution, for example, through the internet, of software to third parties, and supply copies of those in writing. So this is outbound licenses. So if the company has given third parties the right to use their software, under what arrangement has that been made? I guess you can imagine it would also be a red flag to an investor if your biggest customer has paid a once-off lump sum for a perpetual license to the software. That wouldn't be a great future business model. So we're going to want to see what your license agreements look like and whether there are any red flags that the investors need to consider. So the key takeaways over here is, if you're using, all of us are using third-party software, make sure that you're using that within the scope of those licenses. And if third parties are using your software, if you've started to sell and license your software, get those written license agreements in place and keep those in your data room for future reference as well. Data is also a big issue these days. We're going to want to know that the company's entitled fully, without restriction, to possess, reproduce, process, and publish all data of all classes ordinarily held or passed through its systems. So here, and we're going to want to see details of contracts or understanding relating to exchanges of data with other persons. So here the issue is, do you have the right to do what you're doing with the data that you have? Have you gotten, for example, the appropriate consents and the appropriate permissions that you need? And we could also consider the terms of the Protection of Personal Information Act, which I'm sure we've all been bombarded by emails of POPIA compliance, but it is a real thing. and you have to consider whether you're processing personal information. And if you are, do you have the necessary consents? And have you taken the appropriate safeguards that you're required to take by law? Those could also be red flags if there are any issues around data use and data compliance. So I think that's something that is very specific to your particular business and to your use of data, but you need the appropriate rights to use the relevant data for your business. And generally those rights should be expressly granted by the owner of the data. Websites are something we want to know about too. Give us all the websites you run, and let's have a look at your internet service agreements and web development agreements. And please provide us with your email disclaimers, internet policy, privacy policy, security policy, website terms and conditions that are applicable to employees and third parties. Most of you who have a website will have seen internet policies, privacy policies, security policies, T's and C's generally available at the bottom. Those are useful in, clarifying to users of your systems what you actually do with their data and how you work, and also disclaiming liability. So what the IP attorney is looking for here is, have you registered your appropriate domains? For example, if you only have the .coza domain and a very similar company has the .com domain, well, that might be a little bit of a red flag, perhaps not something you can easily address. But if you've got the .com domain, that's better. Have web developers been engaged? And if so, on what basis? That comes back to our issue of third-party contracts and wanting the IP assignment clauses in there. And do you have the appropriate disclaimers and policies on your website that are applicable to your business? Key takeaways here are: engage your web developers just like third-party contractors. Make sure you own the IP and make sure you have confidentiality provisions in there. And have a look at your policies and conditions and make sure those are accessible on your company's website. And the last issue I want to talk about, and then I'm going to show you a graphic where I take you through a process that we look at for an IP due diligence. And then I think we'll get to those questions you guys have been posting. And this is exchange control. Now, exchange control is something applicable in South Africa. And the question we ask here is, has ownership of any IP created by the company been transferred to an offshore entity? Is there any obligation for a company or for the company to transfer IP to an offshore entity? Have any exclusive licenses for IP created by the company been granted in favor of an offshore entity? And if any of these answers are yes, have you engaged with the Reserve Bank? So what we're looking for here is to determine whether there's been a breach of the exchange control regulations. And the key takeaway here is you really need expert advice before transferring or exclusively licensing IP offshore. So here, I'm not referring to simply selling your software and getting money from foreign customers. I'm referring to the situation where a company establishes a holding company and then in a different jurisdiction and then wishes to transfer ownership of the IP held by the South African entity to the foreign entity. That is something that triggers the exchange control regulations, and it's a whole presentation on its own, but just know that there are some issues there that need to be addressed before you can freely assign South African-owned IP to a foreign entity. And that's something you're going to want expert advice on. All right, so this graphic over here is quite busy, but I'll just quickly take you through it. It really talks about what we would do if we sat down with your business and did a virtual or even better, an in-person whiteboard to understand your IP and what the appropriate IP in your business is. So let's start at sort of 1 o'clock over there with create an IP register. So this is a stock taking. We would look at what patents you might have, if any, know-how that you have in your business, trademarks, designs, copyright. Then, I mean, things like pharmaceutical patent extensions, highly unlikely that that would be applicable to your businesses. Are there any regulatory issues, standards, essential patents, plant variety patents? So let's do a stock take and create a register of the IP you have that's important for your business. I would say for this audience, your most important IP is going to be your copyright. So that is the right to, or your ownership in your software, in your code, as well as all other materials, graphics, literary works, etc., used by your business, as well as your know-how, of course, and then and your trademarks would probably be your most important IP assets. And then patents, if you've gone that far, would be a very important IP asset as well. Then we do an IP mapping exercise where we look at your actual products and processes of your particular business, and we consider what types of protection are applicable. Are patents applicable to your business or not? You know, have you filed trademark applications? Should we be looking at something like designs? And to decide on that, we also consider the purpose of IP to your business. Why are you interested in protecting your IP through patents or trademarks? Is it primarily to attract funding? Is it to secure valuation on exit? Are you planning to license this IP from here and have others use it? Or have you got such a great market share, you just want to maintain your exclusivity and stop others from copying it? Or is it a combination of those reasons? That helps us to identify the type of protection that is applicable to your business. We also look at geographical coverage. IP rights are territorial. So South African trademark doesn't give you any rights in the United States, for example. Where are you actually planning to expand your business? Do we need to be proactive and start registering some of your trademarks or patents in other geographies and geographical areas? And how do we make that decision? And then finally, freedom to operate. Do we need to consider third-party IP rights and the possible infringement? Do we need to look at your new products that are not yet launched and do a freedom to operate exercise to see whether you're likely to infringe? I would mention in the tech space, very few companies do freedom to operate. The reason being that patents in this space in particular are very broadly written. Often they're unpublished or they're still pending, and it's quite hard to determine the scope. So usually the advice that most tech companies have is just, protect your own novel and inventive tech, but don't worry too much if you haven't copied someone else's solution. Don't worry too much about doing freedom to operate. That's very different in other technology areas. For example, if you were going to bring out a medical device, or if you were in the pharma space, freedom to operate is really, really important. You don't want to have a product feature, something in your physical product that is going to cause a liability for you when that thing hits the market. So consider how important freedom to operate is to your business. Then the IP strategy and the recommendations at about 7 o'clock over there on our IP audit clock. That is something that really comes out of this process. And it's an iterative thing that you can develop as you go through all of these mind map questions. You also look at internal management of IP. So how are you actually going to, what are your sources of innovation, and who's actually going to make decisions in the company about these things? One of the problems I often see with mid or even large size companies is no one has been appointed as a IP champion in the business. And so it kind of ends up with either a technical person who doesn't have the appropriate business making authority, or it ends up with a legal department, and the legal department isn't quite sure how to address it. So as part of this plan for a business, you need to identify someone in your company to say, you know what, you are the IP decision maker. If you're a bigger business, you might need a steering committee, and you are going to need a budget. You're going to need to decide, what are we going to set aside and budget for this process. And then you've also got to think about your attitude to risk. How are you going to, and that bleeds in again with our discussion around freedom to operate. Are you simply going to launch products and see what happens? Or are you going to do some due diligence? And how aggressive do you want to be in protecting your own intellectual property? And it's interesting here, you see a wildly different approach by companies. Some companies, Oracle, for example, in the US, is known for being incredibly litigious. They will just protect absolutely everything they can, and they won't hesitate to sue competitors. But other companies take a very different approach. Sun Microsystems, before they were acquired by Oracle, had almost the completely opposite approach. And then all of this bleeds into your business plan as well, and has to tie in with what your roadmap for your company is. Does your IP strategy and recommendations align with your business plan? And then again, at sort of 12 o'clock, looking at IP ownership is also really important. And I think I've stressed this point a couple of times now. When you're working with consultants and parties like a joint venture, you're going to need to have appropriate agreements in place that give you ownership of IP, and you're going to want to look at your employment contracts. So I think this IP audit mind map is a good way to fill in all of these details and sit with someone who can help you work through this and really prepare for an IP audit. So that concludes the formal part of the presentation. I'll now, I think, Tari, do you want to summarize the questions for me, or shall I just read them and answer them, or how should we do this?
I've got some noted down, so I noted them down in here on my computer, so I can read them to you. If that's okay.
Yeah, absolutely.
So the first question is from Molatelo, and she says they're a multimedia production company and academy. She's asking if we've established our academy. So when we established our academy, we wanted to secure the use of the name and registered it with CIPC as a trademark. However, we don't know what further steps to take to ensure the name is fully protected. Please advise.
Okay, that's a great one. So it often happens that companies will file their trademark applications themselves with CIPC. It's reasonably easy to do. The problem, though, is that the CIPC isn't really geared to working with the public directly. And, they may, for example, have posted you an issue with your trademark application and said you need to associate the trademark with a different name, for example, or you need to do some formal step, and you won't have gotten that communication, or you won't know what to do. And your trademark application will therefore not proceed to registration. So most likely your trademark application has been filed, but never registered, which means you haven't actually got a trademark yet. So the advice there is to engage a trademark attorney. So my partner, Christine, who I think you've heard from on a couple of the sessions, she's a very experienced trademark attorney. We can very easily look up the status of that trademark application for you and see what next steps are needed. But it is one of those things where working with a trademark attorney or a trademark agent is going to be the way to get that trademark to actually proceed to registration.
Perfect. Thanks, Ralph. I've got a question here from Kathy. And she's asking, so she says her business is an online marketplace for peer-to-peer trade. And once our concept has a foothold in South Africa, we have ambitions of geographic expansion beyond SA's borders. Some of our code and processes will be patentable. Please advise what we should consider in terms of IP protection and registration, given our plans to expand internationally. Should we consider registering now in any particular territory abroad? Are there tax considerations?
Okay, so patents need to be filed before there is a public disclosure or commercial use of a particular technology. So the answer as to, should we register now is you need to file your first patent application before you actually use that technology publicly. And with patents, you have timelines in which to extend those rights internationally. So, for example, if you filed a provisional patent application in South Africa, you then have a year, 12 months, in which to file either direct applications in all of your countries of interest, or there's a different process called the Patent Cooperation Treaty, which gives you another 18 months before you have to select your member countries. So for patents, if you believe your technology is patentable, it is something that you should consider and must consider filing before you commercially use that, because once you've put it out there, you can no longer get patent protection. Just a word on patents as far as software businesses go. Your business is an online marketplace for peer-to-peer trade. What we're looking for patents is a technological solution. So if the difference between your platform and previous platforms is simply a business change, for example, I don't know, connect people in a different way, that's most likely not patentable. It needs to be an improvement in the realm of technology. And the way I often think about that is this a solution, something that if you show it to a software developer, they say, oh, wow, that's a pretty smart way of doing it. It needs to be something technological in nature. But the best answer I can give you there also is, drop an email to a patent attorney like myself and ask them to have a look at your invention and whether it is patentable, and then consider the next steps. As far as tax considerations go, that's outside my field of expertise. I'm not a tax lawyer, but when you're ready to actually expand internationally, you can certainly start doing so from here in South Africa. There may come a time, though, where you want to establish offshore entities through which you also work that perhaps are in tax-friendly jurisdictions. And that's the point at which you should get involved with tax attorneys and looking at your specific situation there. Just remember, before setting up elaborate structures and additional businesses offshore, you will need to have both the funds and the time to spend significant effort on that. So if the question is just getting the business going, focus on the business. I can actually see some of the other questions, Tari. Shall I just kind of keep scrolling? Oh, you've got a summary, I think. Do you want to maybe?
Yeah. Yes, because I've got a question from Matilda. I suppose it goes on from what you said, to have a patent attorney look at their IP. So the question is, are there costs associated with that? And I suppose who specifically in the company would be tasked to coordinate all of those IP issues?
Okay, so the costs, I would say, most IP attorneys, myself included, wouldn't charge anything to have a look at what you've got. We're not going to start running the clock if you give us a call or you send us an email. We'll be able to determine what you need and then provide you with a cost estimate. So my encouragement would be, don't be afraid to get in touch. You're not going to get any surprises. You're going to know what you're in for once we've looked at your business and determined what you need and recommended an approach. I think that's something I can say with confidence, that just talking to us initially and getting us to look at your what IP may be applicable isn't by itself going to cost you anything. Of course, if you end up filing patents all over the world, it gets enormously expensive, but that is probably not an approach that will be applicable unless that's going to be valuable to you. So the cost of the IP always has to make sense and always has to be commensurate with the value to the business. And it needs to be less than the value to the business. Otherwise, you wouldn't incur that cost. And then the next part was who in the company should be tasked with coordinating IP issues. I guess it needs to be the person who feels the most ownership of that project. For a startup, it may well be the CEO or founder that needs to take that on. But with time, it's something that can be delegated to perhaps the CTO or the legal department if you have one. If you do delegate it, though, make sure that it's not something that just gets decided in the dark. Make sure that the overall management of the company takes into account these IP issues as it goes along. But I would say initially it needs to be something that needs top management involvement.
Thanks, Ralph. I've got two more questions. One of which I think we covered, but I suppose it's kind of like a quick summary. It's almost a takeaway. So the first one is, what form of IP can an online marketplace and an SaaS ERP company look out for?
Okay. So an online marketplace, you would certainly have your trademark. That would be really important. And of course, you want your domains, preferably your .com domain. As far as the trademark goes, this will be something that Christine also addresses in her sessions, but try to find a name or a word that doesn't simply describe your business. There's always a temptation when coming up with a trademark initially to just tell everyone what you do. And those trademarks are often very difficult to protect because they are also trademarks that other people need to use. Think about, exclusive books. Not a great trademark because CNA also has a section at the back called their exclusive books section. You want to be Amazon, which doesn't tell you anything about what the company does. And a good test there as well is if you can get the .com domain, then you've already had to create a very distinctive or, had to coin a word to be able to get the .com domain. So trademarks would be really important for an online marketplace. If you have technology that works differently, you might want to consider patent protection. And I think your terms and conditions and your agreements are going to be really important there. You want to make sure that your customers are using your marketplace appropriately.
Ralph, and then the last question is, I suppose, like I said, as a summary of what we've covered this morning, what are the 3 most essential steps to getting your IP investment ready?
So I would say firstly is try and get everything in writing. If try not to have too many informal arrangements. So get agreements signed. Make sure that you own the IP you own would be the second most important thing. So have a look at where your IP is generated and make sure that the people that have generated the IP have in writing agreed to transfer the IP to you. That would be the second most important thing. And then the third most important thing would be, start the process of actually protecting your IP, and the most likely first candidate there would be your trademark application. Get your trademark application filed so that you don't have issues with other companies able to use similar trading styles to your company.
Great. Thank you so much, Ralph. And thank you everyone for joining us. I'm not sure if anyone else has any questions, you're welcome to raise your hand and you can ask now. We've got a bit of time before we wrap up. If not, thank you so much, Ralph, for the insightful presentation. And again, we're always very, very glad to have Von Sydels on board and sharing all the knowledge and experience. And I think there was a comment there that I've been, very, a bit of a dummy, as it were, when it comes to IP, and just learned so much in the session alone. So thank you so much, Ralph. And for all of you in the audience today, if you'd like to hear more from Ralph and Christine, you're welcome to join us at the upcoming SA Innovation Summit in September. And again, sharing more insights on intellectual property in various sessions. So please head on over to our website, innovationsummit.co.za. to apply for to get a ticket to the upcoming summit. I see I've got a hand there. Gilbert, I've got two seconds. Oh, I see. Sorry, Ralph, he says we forgot to address the SaaSer part of his question. What form of IP can an SaaSerp company look out for? I'm assuming it would be the same.
Okay, yeah. So I'm guessing that is a software as a service enterprise resource planning company, which would be a company that is, helping. It's software that's run by the company itself, right, to do their internal management and compliance, things like that. There, I think your trademarks again are going to be very important, because you're going to get referral from existing customers, and you're going to want a trademark that is very distinctive and doesn't seem like somebody else's business as well, so that people can easily find you online as well. And I think your agreements are probably going to be key there. With software as a service, you're going to want to make sure that you can, for example, increase your fees over time. You're going to want CPI escalation clauses at the very least. And you're going to want to have the commercial model for your business and the legal agreements around that commercial model really well defined and well established. And then I think also protecting your confidential information. You're going to want to make sure that you can't lose employees who can just take the code and easily copy your software and perhaps compete with you. So you're going to want to look at your confidentiality provisions in your employment agreements and your contractor agreements as well. It's probably unlikely that those kind of systems would have too much in them that are patentable, but it's possible. So you might want to look at that as well.
Great. Thanks so much, Ralph. If you have any more questions for Ralph or the team at Von Sydels, you're also welcome to email them at innovation@vonsydels.com. It's also in the chat there. My colleague Buntu has posted it in the chat. So again, if you'd like to hear more from Ralph and Christine, please come join us at the upcoming Innovation Summit in September. It's just 3 weeks away. We're very, very, very excited. And once again, thank you, Ralph, and to the team at Von Sydels, again, for always being our IP experts and informing us and giving us all the knowledge that we can and understanding in regards to IP. And I hope you all enjoyed this session. And if you have any questions again for us, please email us at hello@techtribecommunity.com. But for now, thank you very much. And that's it from me. Goodbye.
Thanks, Tari, and thanks for the great questions, everyone. Cheers.